welcome. We're pleased to have you with us. We have two cases on the afternoon docket. They will be called in the order in which they appear. Let me remind the parties that the appellants have the option of reserving up to 5 minutes for rebuttal. So when you come to the podium, after you've introduced yourself, please tell us how many minutes you wish to reserve, and the clock will be programmed accordingly. Typically, each side has a total of 15 minutes for argument. On motion of the parties in the first case, the court has extended that to 20 minutes, and the clock will be programmed accordingly. Are there any announcements or introductions? Please call the first case.
Howard Levy versus James Franks et al.
Good afternoon, Mr. Caparella.
Good afternoon, Your Honors. My name is Donald Caparella of the Nashville Bar, along with Jacob Vanson over here. I represent Howard Levy. I'd like to reserve 5 minutes for rebuttal.
Yes, sir.
This appeal involves the second chapter of a long dispute between Mr. Levy and Mr. Franks. In the first chapter, the previous trial court and Court of Appeals found that Mr. Franks had engaged in outrageous conduct, made false claims of trespass, and committed malicious prosecution against Mr. Levy, violated numerous local ordinances. As, quote, part of an unwavering resolve to use his property as he wished, without regard to zoning ordinances or any other restrictions. Previous courts awarded hundreds of thousands of dollars of compensatory as well as punitive damage against Mr. Franks to deter him from doing it again. It did not work. In the second chapter, we have another spite fence. We have more outrageous conduct, new false claims of trespass, more violations of zoning ordinances, all again in an unwavering resolve to operate his construction company, use his property as is wished, as the ultimate goal of to try to get Mr. Levy simply to abandon his property. I brought these pictures in here to focus on a couple things, but first I'd like to focus on all the claims related to the fence. Here's a fence viewed from Mr. Levy's home, looking outside his driveway to the common driveway. This is the common driveway that goes to Mr. Franks' house that way and back to Holly Hill Road. The first claim I want to talk about is the claim under the City of Franklin ordinance regarding fences. That claim was dismissed on summary judgment by the trial court, partial summary judgment. Now, all the grounds for summary judgment that were made by the defendants, the trial court said, well, it simply rejected them, said, I don't think they're appropriate, I'm not going to follow them. But then sua sponte, the trial judge came up with its own reason to dismiss it under a standing claim. And the trial court said that there was simply no evidence that Mr. Levy had been specially damaged and made several findings of fact. For example, trial court found that Mr. Levy had testified that this fence, which goes around 3 sides of his properties, was higher than this zoning ordinance. It was 4.5 feet tall in some places, at least 4 feet, and the zoning ordinance said minimum of 3, and it faced the wrong way. The finished side was in instead of out. The trial court also found that Mr. Levy had testified that this fence decreased his property value by $50,000. As your honors know, under the rule of evidence 701B, a property owner can testify as to the property value of their property.
And was Mr. Levy's affidavit addressing what he felt was the diminution in the value of his property in the initial response to the motion for partial summary judgment, or did that come later?
The trial court found it based upon other filings in the case, and the trial court made an express finding in her order granting partial summary judgment that that's what he had testified to. It was actually from a deposition or a discovery response, but it was definitely before the trial judge because it's in her ruling granting partial summary judgment the first time around. So she made an express finding about the height of the fence, an express finding about the fact that it's backwards orientation against the ordinance, and she also found that he had testified about the property diminution. Trial court also found that Mr. Levy had put forth several other facts of his own, that this was a safety hazard because at least 2 trucks had backed into this fence trying to get in and out, FedEx trucks. The trial court also found that he had evidence that this was an eyesore, it blocked his view, all damages that were unique to him. And let me show you the second one. The fence that I just showed you was just a portion. It's the portion right here that blocks his exit. Again, the common driveway goes down to Holly Hill Road down here, and the common driveway goes all the way here, and this is the Franks' houses and residence. So this is the common driveway they share. The fence was put up on 3 sides, and you can again see this extreme narrow opening here that blocks most of the asphalt. So, the ordinance claim was about this fence violating the Franklin City ordinance, and the trial court dismissed it on summary judgment, despite clear factual findings that Mr. Levy was the only one damaged by this fence, and you can see why he's the only one. None of the other people here would have any interaction with this fence at all, and he was the only one that suffered a diminution of property. So it was wrongful error for the trial court, and you have a standard review for summary judgment on this, for the trial court to have dismissed the fence ordinance claim, because the trial court expressly said that he has a private right of action. It rejected what the city of Franklin had said about that they hadn't, I think the other side said you didn't exhaust your remedies, and she said, no, you have a private right of action, no question about that. And I'm rejecting all the defense's arguments, but I'm going to say you're not specially damaged. You never proved you were specially damaged, even though the most obvious way you're especially damaged if your property value goes down by $50,000, and that's expressly what the court found.
Does this fence continue around the Franks property, or is it limited to the 3 borders of the Levy property?
The red marks this entire fence, goes nowhere else. As a matter of fact, at this time, when this fence was built, we'll go into the spike fence thing in a minute, it was built, there were no other fences like that anywhere. Now, a year and a half or 2 years later, the Frankses did build some other fences because they own all the property from here over and down, and then around and behind him. But they don't own any of this right here, the Frankses. So this was the only fence of its kind. And I'll go ahead and transition a little bit to the spike fence argument, but let me just finish. There's going to be probably 2 lawyers who will stand up here and say, this case is all about credibility. Credibility has nothing to do with the summary judgment, partial summary judgment at all, because the trial court simply said, you're not specially damaged. I find you're not specially damaged, even though that same trial court found that you lost $50,000.
One of the arguments I understand the appellees are making is that although there was a grant of partial summary judgment, really the court allowed proof of this at trial, and so really there was a second bite of the apple here.
Yeah, and in my reply brief, I knocked that down 3 different times because the trial court expressly said that all that went to trial was the other claims, and the trial court expressly said, this claim did not go to trial. In my reply brief, I point out the 3 different times the court said that this claim, the Franklin City Ordinance claim, did not go to trial. 2 different claims went to trial. The spike fence claim and the nuisance claim. Those claims have very different elements. All you need for the ordinance claim is to show that it violates the ordinance and that the violation of the ordinance specially damages you. So the trial court was wrong to find that, to have facts showing he's specially damaged, and also additional facts that he alleged that were not rebutted, that he's specially damaged because it's around just his property. So that claim should be reversed, and that claim should be allowed to be pursued. Now,
Mr. Caparella, you mentioned that the opening of the fence is narrow. I'm of the impression that the opening is 12 feet wide and the easement is the opening is 14 feet wide and the easement is only 12. Is that correct?
The trial court was very confused about that. I brought the deed with the easement. I can hand it up to you if you'd like. Three copies for you.
I'll take them all.
So that's 3 deeds where this property was transferred 3 different times. It was originally owned by, I think, Mr. Franks' mother, then Mr. Franks himself bought this property, and then he sold it to the Newmans. If you go to the very last page, you'll see something highlighted, the bottom of the page. It shows that the easement that's referred to in the deed, Your Honor, Judge Clement, that deed refers to a 12-foot by 510-foot easement to Holly Hill Drive. So that refers to this 12-foot wide easement down here, which is the common driveway, and 510 feet all the way down to Holly Hill Drive. It does not refer to the opening that Mr. Levy has right here, which is better sent here. There is no easement that relates to the exit of his driveway onto the common driveway. There's no easement that even controls that at all. Now, Judge Davies ruled, because of all the problems with obstructions to his entryway, that there should be no more obstructions, period, to his exit onto the common driveway. And that's one of our claims, that they violated that by putting this. And he also said it should be at least 16 to 20 feet, the opening. Of course, you see how long how big it really is. This is smaller than 16 feet, no question about it. So the easement, the confusion about the easement is made clear by, that's trial exhibit 3 I just gave you with all 3 of those. And it makes it very clear that it's 12 feet by 510 feet. And if you say it's 12 feet, I mean, where's the 510 feet? Where's that reference? It has to be, and since it says to Holly Hill Drive, it has to be this common driveway, 12 feet wide, 510 feet long, back down to Holly Hill Drive. Now, we believe that this is a spike fence and that the evidence preponderates against the trial court's ruling that it's not, for the following reasons. First of all, it was built in the fall of 2015 in retaliation for Mr. Levy having his lawyer write a letter to Mr. Franks saying that this access road that was built for the first time shortly before the fall of, when it was built in 2013, was actually built onto his property. Just a little bit, but it was built on there. And they wrote a letter and said, you got to take it off. It's an encroachment. And Mr. Franks responded by, first of all, he waited 6 months before he did anything. Then he sent a crew out and said, I'll take it off. And he did cut off the encroachment. So there's no dispute that this access road was built on Mr. Levy's land. But he had the same crew build this fence in the fall of 2015. And this fence was built exactly where the other 2 spike fences were built from the first case. The first spike fence was a silt fence. The second one was a 13-foot stockade fence. And there's a picture of that in the brief as well as in the record. Those spike fences eventually went away as a result of the first case. So he built it on the very same location. He also said that he sped up the building of this fence in retaliation of the letter complaining about the encroachment. The argument that they always wanted a fence on their property, because Mrs. Franks always wanted one of these green fences like hers, is simply not credible, Your Honor. It's not believable, because look how the fence is oriented. It goes all the way around Mr. Levy's house, and it also, almost comically, cuts off his asphalt. What could possibly be the purpose of that? So the definition of a spike fence is it has no benefit to the person that builds it. In this case, it's 250 feet from the Franks' house. Certainly building it onto the asphalt doesn't benefit the Franks' in any way. And he admitted that he sped up the building of this in retaliation for Mr. Levy complaining about the encroachment of the access part. Now, we also believe it's a nuisance and a spike fence, and they're almost essentially the same kind of claim. It annoys and hurts the person, and we already have proof of loss of property value because of this fence. We certainly have loss of property value because it's a spike fence. So we believe that we have met the standard for prima facie definition of a spike fence. Now, turning next to our construction claim, there was a construction ordinance that's existed through all the time that they were fighting during the second chapter, well, first and second chapter, that says you can have a home office of your business, but you can't run a construction company or any other business from your residence. So the first trial court said that that's exactly what happened and forbid him from doing it. But it happened again. In 2013, he built this access road and started running all his construction equipment all the way back to Holly Hill Drive and by there. And we have 350 pictures and videos, separate ones, showing hundreds of, I've got to get this, the list of vehicles here. It's dramatic. I'll just go by memory. There are oil tankers, there's backhoes, there's giant dump trucks, there's regular and refueling. There's a tank here, right there, that holds 1,000 gallons of oil, and the vehicles would come in, refuel, and leave 5 or 10 minutes later, or they'd come in, stay overnight, but they wouldn't do any work on his property. They would just leave and refuel, and they're going off to do other jobs. So we believe we established a prima facie evidence of all of that claim. I didn't have time to get to my outrageous conduct claim, but let me just say in summary, that's accumulation of all these things, with the tipping point being bringing back the false claims of trespass. Because remember, Mr. Levy had been wrongfully arrested for trespass in the first case, sent to jail, and then that case was dismissed, and Mr. Franks was found to have maliciously prosecuted him. And then very tactically and with the intent to cause severe injury, Mr. Franks brought back more claims of trespass against Mr. Levy, and even added Mrs. Levy to the claims of trespass. And those claims lasted for 4 years during the litigation, when they just simply non-suited him, but he never promised he wouldn't bring him back. So that shows the bad faith there. So I'm out of my time. I'll save the rest for now.
What relief are you seeking from this court?
We're seeking reinstatement of the claim that was dismissed on summary judgment, finding that we did establish prima facie case for all of our claims, leaving only a trial for the defendants to put on their part. That's what we want.
All right, thank you, sir. We'll hear from you again on rebuttal.
I'd be happy to move these if you'd like.
Leave them now, I may brief you.
Okay.
Good afternoon, sir.
Afternoon. Attorney Alric Henry and Chloe Kennedy for the James Franks and the Franks Trust. I wanted to advise to the court of that the trust and Mr. Franks individually are going to use 15 minutes of our time, and the remaining 5 by Mr. Jones are going to be handled for the 2 corporate defendants.
Very good. 15 minutes. Thank you, sir.
In this particular case, Your Honor, and please the court, again, Al Henry from the Chattanooga Bar. In this particular case, one of the challenges, of course, is the lengthy amount of issues and facts that are addressed by 2 briefs that are in excess of 160 pages. The length of these briefs alone suggest what is indicative here of trying to re-argue the facts of the case, respectfully by Mr. Campanella, that was not there themselves. The attorneys, David Taylor and Mr. Beasley, were the trial attorneys for this particular case, and it was a bench trial. The plaintiffs, if they had any concerns about the quality of Judge Johnson handling the case or some other judge so assigned, could have chosen a jury. They did not. And briefly jumping into the fence issue and why I wanted to briefly go back to these for a few quick points one, in the record and cited in our brief, the first exhibit which shows the opening of the Levy driveway. The testimony included, when I was cross-examining Mr. Levy, first of all, that this driveway width was altered during his ownership. Many years ago, when the Levys and the Franks had a more congenial relationship, you will notice to this triangular portion to the left of this picture that there is a difference in color and texture. This is because it was expanded so that the Levys could add a basketball net. This is covered in the transcript. And that expansion was on trust property and was allowed. The actual testimony in the record is that the width of this opening is some 15 to 16 feet, and that the easement obligations are 12. Now, I know Mr. Caparello went into great extent of even bringing documents for the court to review and interpret it as to the deed. But it is important to note that they chose to abandon their own expert testimony, Mr. Northcutt, in this appeal. They could have certainly, if this was such a strong issue, have relied upon expert testimony to clarify these issues. They chose not to. Amongst other things, it's many aspects of this case that they chose to simply forget about because it was so blatantly clear that the credibility of these witnesses were not accurate and had been actually manipulated, as the court found, by Mr. Levy himself. Briefly, in terms of the discussions and Your Honor's questions about the fence itself, I think Mr. Caparello clarified later, but the fact it is undisputed and admitted by Mr. Levy that this fence, the exact same 4-rail fence, which is the most common fence in Williamson County, goes all the way out to the main road on Holly Hill. It goes around other family members' property because there's other surrounding property of Mr. Frank's mother, sister, and family members. This fence goes out there too. Interesting enough, Mr. Levy doesn't find any parts of the fence that are not around his property to be a spite fence.
Now, are you saying that this green fence extends from the Levy property to the highway? Is that what you're saying?
Yeah, all along this subdivision has Holly Hill Road has one entrance going into it. There's fence, the exact same fence out there. There is a property on the next street over.
But does that fence connect to the fence that surrounds 3/4 of the Levy property?
Yes, because there's a rear drive that is part of the subject matter of this lawsuit. That fence goes past around that back, and actually part of the Levy property had existing fence that was there before in poor condition. I think it was like wire and wood when we went out there.
So can you show on that diagram where the 3-sided fence connects up with another fence?
In this picture, as I recall, there's fence that goes down the and this, of course, at a different period of time, goes down the common driveway out to the street, goes along the front of the street. This fence goes. There's property, I think, of the sister and Mr. Frank's mother on this side. The fence is out there. The fence, I think, stops as you get to some of the agricultural fields back here. But this does not at all represent.
But you're saying the fence literally connects. It's screwed to or nailed to the part of the fence that goes around the Levy property. It connects. The question is, does it connect?
Yes. Now, the extent of all of the points I'm talking about.
You pointed at 3 different spots. Where does it connect?
As I recall, and of course I didn't bring extra pictures there, that this fence continues from this point of the driveway going out this way.
The photograph at your foot there says to the contrary.
Well, this is goes out, well, at this point in time in terms of that, it goes around that side. I think there's also some of this green fence back there in terms of,
Well,
candidly,
from the vagueness of your response, I'm taking it that they do not connect unless you can convince me otherwise.
Your Honor, I'm not positive. I thought that it did go this way in terms of that from recollection, but I didn't honestly bring pictures in that
Assuming they
regard.
don't connect, what benefit to the Franks resulted from the construction of the fence around 3 sides of the Levy property?
One, Your Honor, they had indicated, as Mr. Levy admitted in his testimony, that he knew the Franks for some 30 years were planning to fence around the extent of all of their property. This is landlocked property. All of the property around Mr. Levy's property belongs to the Levys. Further, in the regards in the testimony about some of the...
And that benefits the Franks how?
The Franks had indicated, one, that they wanted to, and Mrs. Franks, have the entire property fenced as she was when she was growing up. This is something Mr. Levy acknowledged. The fact is that the fence is attractive. It is a common fence among most homeowners in terms of that. So
I don't doubt that, but, okay, please continue.
I would like to ask a question about compliance with the fence with the City of Franklin ordinances. In support of the motion for partial summary judgment, was there some affidavit indicating that Coates had looked at this fence and it is in compliance?
yes,
Okay.
there was, as part of the summary judgment, there was an affidavit that was admitted from the City of Franklin in this particular case.
And is there not any setback that applies to a fence? I mean, the fence seems to just ride the property line, and I would have imagined that there would be some minimum setback from an adjoining property owner's property line, so it wasn't sitting right on top of the boundary. Is that not the case?
Well, and the evidence is trial in that regard in terms of the setback. I do not recall that Mr. Northcutt discussed about issues on the setback.
Setback,
Indeed, the credibility of Mr. Northcutt was so bad, not only is recognized by the court, but they dropped all that issue relating to that as to the setback. In terms of the fence and completing the answer by Your Honor as it refers to the city had investigated whether this is a violation and looked at the issues such as the size of the property, which was some 16 acres, and the fact further, as even interesting to note, and I think this is 2015, they describes it as agricultural in nature as it relates to this particular property, and indicates it did not violate the zoning as it relates to this fence regarding its location. It goes into discussion amongst other things as to its location, its character being similar. This was the affidavit of Chris Bridgewater, basically an analysis of this, that it wasn't in violation. Also references about the fence being on Holly Hill and common to others in the area. And in this particular ruling, Mr. Levy chose not to appeal. Interestingly enough, in terms of some of the issues on the fence, as issues such as, for example, the allegations of spite fence and of the fact that it caused emotional trauma, the fact is that the plaintiff's own pleadings are inconsistent with that belief. While the plaintiffs argue that they're hypersensitive to these issues because of past experiences some 20 years ago, the original complaint was filed October 1st of 2015. While there is a mention of a fence in the complaint, apparently in 2015, Mr. Levy didn't think it was a spite fence, because he doesn't say that. He doesn't claim there's any emotional distress whatsoever, in spite of all of this argument to the contrary. Then in May 8th, 2016, he adds the trust in another amended complaint. Still, it's not a spite fence in 2016. No emotional trauma in 2016. October 27th, 2017, he adds additional defendants and allegations of emotional distress. Does not, at that time, talk about a spite fence. It's not until April 26, 2018, that he goes into allegations of a spite fence. I did not see in reviewing any of the pleadings actually that he indicates he suffered any emotional trauma regarding any counterclaim or allegations of trespass as it relates to the case.
But he did allege economic diminution in value of the property.
And that was insufficient. First of all, he had an appraiser that he brought in, Mr. Atwood. Again, went to the trouble of getting an expert. That expert did not testify there was any diminution of value. Only that if it is proven there's an ordinance violation, and if it is proven that there's any encroachment, then it would have to be reported to the new purchaser. That was it. So they went to the trouble of bringing that expert in, not to give any testimony whatsoever. Then, in reference to the vague discussions of Mr. Levy does not give any basis, foundation, or explanation for him just throwing out in a testimony about, well, $50,000. The reality is, I think that everyone in this room can agree. The span of time of this case, property in Williamson County is probably doubled, tripled, or quadrupled. How from this, when you have no testimony about encroachment or any problems, including to the opening from the experts they put on the stand that was sufficient, or from their own appraiser, how there is a reasonable basis that an individual that the judge has reviewed as lacking credibility to be the sole basis. In addition, in reference to discussions of special damages, it was brought up during examination, including of Mr. Franks, confirming what Mr. Levy agrees to, that into the Red Wing subdivision there's only one entrance before you get to this shared driveway. And every single vehicle alleged to have come in has to pass through the entrance to the subdivision, houses on both sides, before they're entered into the common driveway. So every single other person is exposed to this terrible amount of traffic that he alleges that caused him this distress. In fact, I do not recall any response, including even an opening argument once that point was brought up, that there was any special damages, because all of this vehicles and the traffic as it relates to it is the same thing that multiple other neighbors would have seen. There's no pictures as it relates to any work actually going on at the property, and indeed the judge comments on many things, including the fact that one of the pictures admitted by the plaintiffs is a vehicle that's used to mow the common driveway. There was also, as I indicated in here and kind of wrapping up as it relates to my time, multiple other substantial issues that are related to credibility. Because again, this is an instance where the plaintiff put on 2 weeks of proof. 2 weeks of proof that they put on in this case that was supposed to last 4 days. They called everybody, including Mr. Franks. And the fact is that the judge, who they selected an alternative to a jury to hear this case, found Mr. Levy not credible, not believable. The judge, Johnson, worked hard in this case on a 75-page opinion, went on site to do inspections as it relates to this particular case in the property. Mr. Levy constantly flip-flopped in terms of his testimony. There's been indications and record to Mr. Northcutt that he found pins and evidence and told him to change his recordings, that they made allegations of how Mr. Levy is driving erratically, but then the testimony was basically given up on appeal relating to those issues. There's allegations that Mr. Franks stole the FedEx package, and Mr. Levy called the police. But he admitted there's no proof of that, as there was no proof relating to the gunshots and many other issues. This case is a lot more complicated in terms of trying to win on an appeal in this particular issue, and is being clouded by the very skilled but not on point as to what's actually in the record in this particular case. I think my time is up, and I appreciate very much your patience in hearing arguments.
All right, thank you, Mr. Henry. Mr. Jones, good afternoon.
Good afternoon. Please don't start that clock just yet. Please the court, Philip Jones, the Nashville Bar. I represent all 4 of the defendants. I have 5 minutes. I'm going to departmentalize my comments into 3 areas. There are 6 lawyers here today. This case has been proceeding for 8.5 years. Mr. Levy had a team that filed his lawsuit. He had a second team that litigated his lawsuit, a third team that's handling his appeal. As he amended his complaint a 3rd and 4th time to add additional defendants beyond Mr. Franks, Franks Trust, his company Tennessee Valley Homes, his company Old South, each of those put me in a position to bring in co-counsel. I have the unique position to be the only lawyer in this case that's been in it from day one. I'm pleased to say I was not in the first case. I've read the opinion. Mr. Frank's conduct was sanctionable. He took it on the chin. He paid those. Those are not relevant for purposes of this case, although hours and hours of this trial talked about the first case and not the actual evidence in this case. So I give that for purposes of context. I'm the one that obtained the partial summary judgment. This second point that I want to make is this. Because I'm so familiar with Mr. Levy as a litigant, I'm keenly familiar with what the judge was able to detect rather rapidly. This case was scheduled for a 5-day trial. Mr. Levy took all 5. We came back for another week. I think he took 4 days or 4.5 days. At the conclusion of that, she dismissed the claims, took it under advisement, and issued a 75-page ruling dismissing all of those claims. 12 times in that opinion, she says that Mr. Levy is not credible. Twice on page 7, 3 times on page 28, 3 times on page 29, page 42, 56, 62, 72, and 73. She did not varnish her words. At one point in the opinion, she says he's utterly not credible. At another point in the opinion, she says he has an extreme lack of credibility. That's important for your work today, because while your review is de novo.
Credibility findings are important, Mr. Jones, I agree with you. But does a credibility finding matter if it's a question of whether it's a 3-foot fence or a 4.5-foot fence?
It does not, but you or Judge McBrayer brought up a good point. Even though I obtained a partial summary judgment on that, and even though over our admonishments, he effectively put on his proof on that claim. He got to relitigate the Rule 56 motion over the course of a 9-day trial. And we did submit proof in support of the compliance. We submitted an affidavit from the head of codes in Williamson County that said we've been called out there for Mr. Levy 3 different times. We find no codes compliance issues. They also then deposed him. He affirmed that position at the summary judgment level. There was no proof to the contrary.
But is the opinion of an official with the codes department binding upon a trial court if it's called upon to make that determination?
It is not binding on this court, but I think the key point is what you touched on. You said, what do you want from us, Mr. Caparella? And what they want is to go be sent back down. Their proof is closed, it's encapsulated, it is what it is, anemic as it is, and have us put on proof. But if you'll recall, trial counsel made a tactical move, and sometimes that works, but in this case it did not. They actually called Mr. Franks in their case in chief, and he was asked questions, and they were able to lead him, and he gave his rebuttal to their case. So to draw an analogy, they start out on their goal line, they've got to get a preponderance of the evidence, which means they've got to get 1 inch past midfield. After hearing that proof for 9 days, including Mr. Frank's responses, they got moved back to about the 5-yard line at best. Certainly didn't carry their burden by preponderance of the evidence. And that's key because the judge also addressed Mr. Frank's credibility on 2 different occasions and said he was quite credible. So while your review is de novo, that judge saw, heard, observed Mr. Levy for 9 days. And that, we respectfully submit, must be given great weight by this court. And I think that's put out by the Burton opinion, which we cited, and the Dorning opinion. Those are both opinions of this court, one from 2002 and one for 2007. And in fact, something happened in this trial that I've never seen. And it's memorialized on volume 42 of the appellate record, starts on page 159, carries over to page 160. She said, "Time out, everybody. We're halting this trial. We're going to be recessed. I have extreme concerns about Mr. Levy's credibility. I want to go out there and see this myself." The lawyers went, the electronic court reporter with her battery-operated unit went, the judge, the bailiff, and we were out there for about 2 hours, and the judge questioned Mr. Levy. And I think that was very telling, and she based her ruling in large part on the admissions he made during that site visit. So that's the confines of why we're here today. While Mr. Frank's conduct in the first case may have been reprehensible, he learned his lesson. I was not involved in that case. When I got involved in this case, I said, "You better live at the foot of the cross. Don't do anything to rile this gentleman up." They sued Mr. Franks, and I said, "Counsel, he doesn't own this property. You need to sue the trust. You should non-suit him." They added the trust but didn't non-suit. Then they added this one company. Then they added another company on every claim conceivable, including civil conspiracy. And if you'll find in the record.
Let's talk about operating a business. What is the purpose of having a fueling tank on residential?
Well, it's not oil, first of all, it's a diesel tank, because behind this, which we went on the site visit, is an area of probably 3 or 4 acres of corn. This road goes back to his tomato patch. His mother lives here, his daughter lives here, and yes, she does have a green fence, and it does connect. There's an obtuse point where his fence is there and her fence is there. So hers is in green, mother's is in green. His sister lives here, who's married to, I believe, Doug Hale, a lawyer in Franklin, and all of this. So to the extent we need a nexus connection, it is connected, but it has aesthetic and structural symmetry for 1 owner, 2 owners, 3 owners, 4 owners, including down here another relative. That takes me to a final point, and then I'll get to my final point on this issue of credibility. During cross-examination, Mr. Levy, I was pressing him. "I need facts, Mr. Levy, not thoughts and supposition and conjecture." And he said, I'm probably paranoid." I took my phone out, Googled the Webster, put it on the Jumbotron. I said, "That's Webster's dictionary of paranoia. Is that what you just described? People that assert facts that don't exist in reality?" And that's really what we have here. So while the court might grapple with whether we have a zoning violation, all of these other claims stem from Mr. Levy's testimony, which was horrific, tough to watch. It was so scripted. Many times he interrupted his own lawyers and said, "Well, I'll get to that next question, but I want to say this point." It was like a Shakespearean expose. It was a scripted cinematic production. I felt sorry for his trial counsel, but it was what it was. That takes me to my final point, and those are the claims against the 2 corporate defendants, which were added years after the fact. They claim that there's civil conspiracy. And we asked Mr. Levy, "Well, why have you sued these standalone companies?" "Well, Mr. Franks is the trust, and the trust is this company, and this company is Mr. Franks." This pierced the corporate veil analogy. Well, that was, again, supposition and paranoia. We introduced certified records from the Secretary of State that show these are standalone companies. We produced a CPA during the pretrial that talked about they had their own tax identification numbers. We introduced overhead shots just like this of Tennessee Valley Homes and Old South corporate headquarters 4 miles down the road on Noah Drive that has staff there, some 15 to 20 people. And here's the key thing. He says, "Well, he's running his construction empire out of his house." We introduced this Google overlay, which I think was taken in 17, and one which he actually introduced for 2010. Same house, same barn, same house, same pool, same garage, same shed. It must be underground housing if we're doing construction out there. No new structure has gone vertical. Mr. Franks, who they elected to put on the stand, said, I'm not running my construction businesses out of here. I have a separate corporate office, but I have a 16-acre farm, and I take care of it, and my daughters, and my mothers, and my sister-in-law. I'm running tractors in here, I'm dredging out ditches, the Harpeth runs around here. That's not an oil tank, it's a diesel fuel tank, because he runs equipment to mow, cut, bush hog, plow, disc, cultivate. That little spot is about 1/4 of an acre. This greenery back here is about 4 acres, and there's photographs of it in the record.
All right,
So,
Mr. Jones, if you would wrap up, I've given you several extra minutes already.
I apologize. One final point. This court has held, actually it was the Supreme Court held in the TrawMed case, you can't be an accessory to yourself. So if Mr. Levy's theory was correct, that these standalone entities and Mr. Franks are one and the same, the civil conspiracy claim dies. If they're not one and the same and they're separate and distinct, it's not a separate tort under Tennessee law. It's a parasitic tort. There has to be an underlying tort, and there was no proof in the record we were involved in the installation of the fence, the paving, or anything else, so that claim dies as a matter of law. Thank you.
Thank you, Mr. Jones. All right. Mr. Caparella, we're going to add 5 extra minutes for Mr. Caparella because we gave Mr. Jones and Mr. Henry extra time.
Thank you, Your Honor. I appreciate that very much. When this fence was built in fall of 2015, there were no, and this is 2 years later. So we're, a couple, two years into it. There were no of these green fences you've talked about. You can't see them on here anywhere. These so-called fences that connect. We submitted an appendix of multiple pictures, and you will find multiple pictures, and you will not see any of these fences that supposedly connect because they start way down here, hundreds of feet away. They do not connect. There's no network of green fences that they wanted that they're talking about until way after the lawsuit got started in 2015, and even years after that. I don't remember anything about what's happening back here, but the idea that Mr. Levy has to say, all these spike fences that I can't even see from my house, I have to say they're spike fences too, or this can't be a spike fence. Remember, the history of this case matters. The trial court expressly said that I can and should consider the first case, trial court and Court of Appeals opinion, but then she didn't. There's nothing in her memorandum of law that shows she really considered it. She just made a couple of references to it, but she never talked about this really bad conduct. So I submit that the idea that was stated here, that this green fence connects, it does not. You can't see it here, see it real clearly, that there's not there, and it does not connect in any way to this fence. This is isolated, and it's right on top of the exact same footprint as the previous spike fence that the trial court found. The idea that Mr. Jones said that this was a second bite at the apple on our fence ordinance claim is simply belied by the trial court's own findings. The trial court summarized the course of proceedings in a memorandum, noting that it had granted motion for partial summary judgment and had dismissed it. She said the case proceeded to trial on all of Levy's other claims except for the above referenced code violation by which the court granted summary judgment to Franks and the trust. That was dismissed. It's in her own order, and you will not find any other mentions of a claim that was dismissed anywhere else in the record. So their only real argument in their briefs that the partial summary judgment was wrongly granted was not that it was granted in error, but it was harmless error because we supposedly had a chance to put that case on anyway. So that claim falls down. The argument was made that the first case is not relevant. Well, the trial court found it was relevant. It just didn't consider it. The trial court found that particularly when it comes to outrageous conduct, you have somebody who has gone through, as what Mr. Jones said, reprehensible experience that resulted in punitive damages, which are very rare in Tennessee. And Mr. Franks apparently was not deterred because he did some of the outrageous things in this case, such as bring back these trespass claims. And let me discuss that a little bit. After Mr. Levy filed his lawsuit in 2015, there were 2 or 3 amendments of the complaint. And then when Mr. Levy brought his outrageous conduct claim, before the outrageous conduct claim, Mr. Franks, in response to the outrageous conduct claim, he brought in these claims for trespass against Mr. Levy. And then he added claims of trespass against Mrs. Levy. And then there was a deposition where Mr. Franks testified and said, I have a map that shows all the people, all the places that you've testified on my property. And that's when Mr. Levy said it's too much for him. That's when the only physiological symptoms of emotional stress started to surface. Nausea, sleeplessness, loss of weight, all the things that you get. And the only way to determine severe emotional injury is with physiological symptoms. And 1 month after that deposition is when he went to see Dr. Godwin and then Dr. West. And then he filed his claim about outrageous conduct, a claim about trespass and outrageous conduct after that. So therefore, he filed within 1 year, filed a motion to amend within 1 year of the allegations of trespass. And the trial court made an error of law. She said that you have to, the complaint was filed October 26th of 2016. The trespass claims were October 26th, 2016. You didn't file your outrageous conduct claim based on the trespass claims till a year later, but you measure the 1 year from the motion to alter or amend, and she simply missed that, and my opponents don't respond to that at all. So now, as happens in Franklin, sometimes you get another judge for a while on a case. Judge Martin said, you have to produce discovery of your trespass claims, Mr. Franks. And he never did. And he never did. And eventually Judge Martin said, I'm going to sanction you for attorney's fees for not putting on any, it's in my brief, not providing any evidence in support of your trespass claims. So I'm going to say, while you can testify about it, Mr. Franks, you can't put on any witnesses, you can't put on any documents, you can't put any proof on your trespass claim. And yet it still didn't get non-suited until a couple years later after that. So that shows the bad faith of those trespass claims. It also shows that Mr. Franks was aware of the severe mental injury he had caused when he had Mr. Levy arrested from his own home all those years before. That establishes the outrageous conduct in this case. Now, there was discussions here about the site visit. It's true that during the trial, there was, Mr. Levy was testifying about all the pictures that he had of equipment, heavy equipment being used all around here, going to there. And also, he took a picture tried to take a picture of this tank. But in that 12 pictures, one picture was a really close-up picture of this tank, right there. Like you had to be standing right there on Mr. Levy's property in order to take a picture of that tank. And opposing counsel said, aha, it looks like somebody's trespassing here. We never produced that picture. We didn't produce that picture. And the court said, I got a problem here. Looks like we have some credibility issues. Let's do a site visit. Now, later on, when the trial came back, opposing counsel admitted that that first picture of the close-up of this tank was given to us by them. So that was a canard. That never actually was our picture. But the trial court, and I spent a lot of time in my reply brief, and I apologize, but I did stay within the word limit, shutting down the idea that the trial court found, while the trial court found that he may not have been credible about some things in the site visit, just flat out, she never said that he trespassed or admitted to trespassing. There's a finding of fact in her opinion that says Mr. Levy admitted to trespassing. And I said in my initial brief, doesn't exist, you can't find it anywhere, and the other side has not come up with a citation showing that he ever admitted to trespassing. Now, I also address in my reply brief all the extensive, almost gratuitous attempts by the trial court to say he's not credible. First of all, the court said blanketly, most of his trial testimony is not credible, said the trial court. And the Court of Appeals and Supreme Court has taken a very dim view of that kind of blanket finding of lack of credibility. So you have to look at what is being actually testified to. Mr. Jones mentioned several different times that the trial court found no credibility for Mr. Levy. But look at each one, and I isolate them in my reply brief. They don't relate to any of these claims. And I'll just go through them really quick. The ordinance claim, the fence ordinance claim cannot be affected by liability because it's dismissed on summary judgment. okay?
Cannot be affected by liability.
By credibility.
Oh, okay.
By any issues of credibility, because, I mean, there's no question the trial court found and that Mr. Levy testified about the diminution of property. Now, opposing counsel said, well, property values have gone up 4 times since then. Well, that means this fence, this ridiculous fence that looks like Mr. Levy built it. Actually, Mr. Franks built it. And it's built all along the property line. Now, it's true that we abandoned our claim that the fence actually was built onto the Levy property. We abandoned that claim because Mr. Northcutt did not testify very well, and I didn't want to waste this court's time on that. But the only claim we abandoned was that this fence was built on the Levy property. We have not abandoned that it's a spite fence or that it violates the city ordinance. So we have the spite fence that...
What bearing does the testimony of the city official have on whether it violates the ordinance?
None. Trial court is free to ignore it, and the trial court did ignore it, and granted summary judgment on a completely different issue involving standing to sue.
Specially damaged.
Right, and the law is very clear that you have a private right of action if you're specially damaged, and we believe we've established that. Got a couple more notes I want to check. Again, in my reply brief, I respond to a lot of the statements that were made here. There's no farming operation until 2020 or 2021. The pictures are very clear. And council specifically said, there's been no new buildings built here in 20 years. So we're not operating a construction company on our property. We never said there's operating a construction company where they're building buildings on their property. What they're doing is they're running a construction company in and out to get refueled and get ready to do other jobs somewhere else. Why else would you have a 1,000-gallon diesel tank? Lawnmowers don't run on diesel. And you certainly have no basis. These are birthday parties. And the only person that testified about any income from farming operations was Mr. Franks' co-trustee, who testified that it was $1,000 1 year for tomatoes, and it was a wash. So just like, I'll close with this. Just like the previous Court of Appeals found, the explanations to excuse all this bad conduct is based on coolly implausible or prevarication or guile, or in many cases done with malice, like the trespass claims, that support that we had a prima facie case for all of our claims, and if you look at the credibility findings the court made, they either aren't supported by the record or they don't relate to the actual claims. So we submit that you should reinstate our case and allow just the rest of the case to go forward, because we've established a prima facie case.
All right, thank you, Mr. Caparella, Mr. Henry, and Mr. Jones. You have given us a lot to think about.
Thank you.